Hi, welcome back to the Gorton Law Immigration YouTube channel, and this box represents one client file that I worked on for 5 years that required the client to travel outside the United States to complete their immigration journey, and this is the story of what happened next, aka the State Department's newest trick to hold up visa approvals. I'm Jamie Gorton, and I am the lead attorney at Gorton Law in Malden. We're located outside Boston, Massachusetts, and we help families unite legally in the United States. We help employers hire and retain world-class talent, and we represent the rights of immigrants who are faced with removal from the United States. And among the many other tasks that we do, we have to work with consulates around the world to make sure that visas and immigrant visas get issued correctly and promptly, which is the topic of today's video. And before we begin, first we have a word from our sponsor, which is Red Pilot G2 ink pens. When you absolutely need to tell immigration that you're the one who knows what they're talking about, and you're afraid that their scanners will not pick up a highlighter, red ink underline is the way to go. Red ink pens, saving the day since, 1913. Sounds good. So what's going on here was obviously a very complicated case. You don't get to get your own banker's box with it being an easy case. And finally, after about 5 years worth of work for my office, not to mention work done with previous offices, we ultimately get the case sent down to the consulate, and the interview day comes, and I get the phone call that morning, and I cross all my fingers and I cross all my toes, and the client says they refused the visa. And this is now a trend we've seen over the last 12 months of what the State Department is doing in its consular operations to hold up approvals of visas, in particular immigrant visas. So this is when a case gets sent into something called administrative processing. Now, what is administrative processing, and why is it happening, and why is it happening more, and what do we do about it? Well, a little bit of history. When I first started my career, administrative processing was more of a buzzword for a request for a security advisory opinion. In other words, the file is getting shipped off for background checks, and you're not going to get your visa issued to you until the background checks come back squeaky clean. And so administrative processing was almost universally used for this particular sort of process. And if you lived in a Muslim country, you were much more likely to get administrative processing. Oh, wait, that sounds discriminatory. Oh, no, it wasn't based around Muslim countries. It was based on the following list of countries: Afghanistan, Algeria, Bahrain, Djibouti, Egypt, Eritrea, Indonesia, Iran, Iraq, Jordan, Kuwait, Lebanon, Libya, Malaysia, Morocco, Oman, Pakistan, Qatar, Saudi Arabia, Somalia, Sudan, Syria, Tunisia, the United Arab Emirates, or Yemen. So forgive my confusion about the Muslim issue. These days, we have seen a huge trend of people going to their interviews and just right away the consulate is marking the visas off as refused. And this is because of how they are apparently changing their internal processing, and they're no longer willing to just make yes or no decisions on the spot for visa applicants. And we have seen mothers of U.S. citizens, spouses of U.S. citizens, children of residents, children of citizens. My office has represented all of these types of cases that all get this initial refusal decision put into the computer. And this is because of, well, apparently inability to adjudicate cases on the spot. It used to be people would go, they'd attend their interview, they would come back and they would say, Attorney Gorton, they'd already made up their mind before I sat down. I sat down. It took less than 10 minutes. I was in, I was out. They took the passport. No big deal. These days, it seems like to be a big deal for everyone, including this client here. So what you have as an issue is this thing called 221G. And 221G is on the list of all of the reasons why someone at a US consulate could take out the red pen and say no. At the very bottom of that list of checkboxes, there's a checkbox for basically other, and that is like 221G. And whereas we used to universally say that administrative processing was about security background checks, now we see that there's two kinds. There's the security background check kind, and then there's the consulate just isn't going to say yes right now kind, and that the consulate needs something else from you. So let's hear in the State Department's own words what's going on. So from their info page about this topic, there are only two possible outcomes for complete and executed U.S. visa applications. The consular officer will either issue or refuse the visa. If a visa applicant has established that he or she is eligible for a visa, the consular officer must refuse the application. However, in accordance with department procedures, a consular officer may determine that additional information from sources other than the applicant may help an applicant establish eligibility for a visa. In these cases, visa applications are refused, warranting further administrative processing. So this is the first issue when I get the phone call from Brazil. Oh my God, they refused the visa. Well, no. Did they say why they refused you yet? Did they give you a paper with a bunch of checkboxes, and did they tell you there's a specific reason? In her case, they said yes, and that's a different story. But in general, the answer is no. They just said that, like, I just looked online, and on the computer online, it says refused. Well, there's only two messages that computer can show you, and if it doesn't show yes, it's going to say refused. Wow, like that's a decision that they had to make, I guess. So what is happening here? Number one is it can just be as simple as they need time. Like they need to run some Xerox copies of some paperwork, but someone else was standing at the copy machine, so they had to go do something else, right? When you see the mother of a U.S. citizen getting placed into that administrative processing, and this is a woman who has never been to the United States, has never been arrested, has no reason whatsoever why she can't come in, and they have to do administrative processing for her, well, you cross your fingers and you hope it's not because they're doing complex background checks. You're hoping it's because they're a couple weeks behind in their work, and so administrative processing it is. We were talking about this video topic with my staff, and our immigration associate said, oh yeah, my friend's grandfather just got a 221G when he was trying to renew his tourist visa. And they said that they needed more address history, they needed more employment history, and they needed grandpa's social media accounts in order to make a final decision. And that was enough to say visa refused pending administrative processing. So it is, in my opinion, a very pernicious trend. And based on the shape that the consulates are in, it's not likely to change anytime soon. It is worth repeating that most consulates are probably not in a great shape after the 4 years of the Trump administration basically waging internal war on any sort of diplomacy with other countries. So I expect that in many countries, a lot of qualified and experienced staff decided to lose or leave their positions, or perhaps people did in fact lose their positions, I don't know, and there would be then gaping holes left in the staffing of the consulates amongst people who know how to do this, or the career civil service officers who were in the diplomatic corps who we were all relying on to get these decisions made accurately. I'm guessing that a bunch of them looked at what was going on and said, hey, nothing personal, but I got to do something else for work. That's a big piece of it. I think that maybe there may have been some standards that have changed internally. I don't know. I haven't heard anything about this, but it is very different. Starting I'd say summer of 2021, with things around the world really reopened after COVID, we saw this phenomenon happening more and more and more. So what can be done about it, and what can any given person do for any particular situation? So what is going back on here with this box? Well, in this box, the consular officer totally blew it and did in fact refuse the visa, and did so for reasons that were legally and factually incorrect. I don't know why. The client had all of the paperwork in their hands. Everything was inside of the computer systems. The consulate surely could have just gone into their computer system the same way that I could, put in the A number for this case, get the same information I can get that's publicly available about this applicant's immigration history, and to see that there was in fact no legal reason why they should be refused a visa. Well, in that situation, when the consulate refused a visa and it was honestly a mistake, the only option you have is to, excuse my English, raise hell. We immediately emailed the consulate. We immediately sought help from our congressional delegation and the liaisons that they have to sort this out. We immediately reached out to the State Department's legal net to inform them that there had been like a very major error, made. It was like saying, oh, Attorney Gorton is wearing a green tie today. The answer is no, it just wasn't true. And in that situation where there is something where you need to fight back against the consulate, you have to just go hard and fast and loud and make it happen. It's something that if you're represented by an attorney, you need to see your attorney jump up like they just got bit on the bottom and really get to work. In less dramatic cases than this one, the answer may be small pieces of information like the grandfather in Israel. The grandfather in Israel needed to provide some address history, and apparently, I don't know, they want grandpa's TikTok, they want grandpa's, Facebook profile. It's on the form, so you have to give it over. I don't know what else to say. So I hope that makes everyone in America feel safer. Sarcasm aside, it may be something where there is some sort of thing that needs to get verified with the paperwork. We had someone who had to remain outside the United States for about 2.5 years pending resolution of their process. And when all was said and done, their visa status read refused because they needed to have the consulate verify that USCIS had approved the necessary waivers needed for the person to re-enter the country. So it could just be internal, it could be external, it could be not enough staffing, it could be garden variety delays, it could be that they need a security advisory opinion, it could be that unfortunately they look at your name and they see your name is El Chapo, and that's going to trigger some red flags, or that someone with your name and date of birth was, running a gang in Los Angeles and had been already deported, and that's creating a conflict. It's impossible to tell. And most of the time, the State Department says that they will clear this issue up for you in about 60 days, so approximately 2 months. What happens if they don't? Well, the consulates are like their own little kingdoms. They do not get reviewed on their decisions. The judges cannot reach in and second guess them. The United States Immigration Service does not have any ability to supervise or oversee what the State Department is doing. So the one thing that you can do is you can sue if it takes too long. And suing over administrative processing delays is perhaps the most common reason why someone would bring a lawsuit called a writ of mandamus against the State Department. It would be something that says, you owe me a decision. You must give me a yes or no decision, and it has been unreasonably long. Unless you really think I am El Chapo, you need to give me an answer. So If you're in a situation where your case goes into administrative processing, the first and immediate thing is that you should not panic. You should stop and you should see, did the consulate tell you in writing that there is a specific reason why your visa is being refused? And if they are not giving you an ironclad no, usually in writing, on the spot at the interview, then you can assume that your case is still being worked on. That they have to say it's refused, because if it's not approved, it must be refused. Beats me. So that's the first step, is do not panic. The second step is to comply with whatever requests the consulate has for you. If the consulate says jump, we say how high, and we do it cheerfully with big smiles, and we hope it all works out for the best. And finally, if the processing time for your administrative processing case has become unreasonable and you think it's something that has nothing to do with national security, and you don't think it has anything to do with a security background check or security advisory opinion, and it has been an unreasonable length of time, you should reach out to an experienced immigration attorney who is able to get into the federal courts and is able to do these writ mandamus litigations for you. Not every immigration attorney is interested or able or has the license needed in order to do these writs. So you might make some decisions about if you want to work with an attorney locally where you are, if you want to have a law firm in Washington, D.C. that does these nationally represent you, you should get some counseling from an attorney as to whether or not the delay that you've experienced is something that is likely to be solved through bringing a lawsuit against the State Department. And as always, working with a lawyer that you like and trust is extremely important. The process is stressful enough. You don't want to be working with someone who is just making the process more stressful or more irritating. So this is, as far as we can tell, the State Department's newest trick to hold up approvals of immigrant visas and non-immigrant visas alike. Our judgment, same as always, you gotta just keep plugging away at these. You have established legal eligibility to get classified for a visa. The consulate is there to make sure that all of the I's are dotted, all of the T's are crossed, and that you are not legally ineligible to get what you are asking for. And for them to just slide the pile over to a ever-growing large stack of maybes, at some point that does become unacceptable. So thanks for sharing this information with us. Thanks for joining us, and we appreciate the chance to broadcast this information out to you. We're Gorton Law, based out of Boston, Massachusetts. We are able to bring the mandamus lawsuits here in our home of the Federal District of Massachusetts. We're also barred in the Federal District of New Hampshire and can conduct similar litigation there. If you're experiencing administrative processing delays, or if you just get that refused message on your or your relative's visa, give us a call and set up a consultation with one of our adept immigration attorneys, and we'll see what we can do to resolve the situation for you. Thanks for joining us again, and we'll be bringing you more tips and tricks and sneaky tactics from the government in our next videos.